Wisconsin is officially out of the Texas versus United States lawsuit. This has been ongoing litigation challenging the Affordable Care Act, the individual mandate, guaranteed issue provisions, community rating, and other elements of the Affordable Care Act. Wisconsin was one of the states that aggressively argued that the Affordable Care Act should be repealed. But now we have a new administration, and this new administration in Wisconsin, a new governor, a new attorney general, disagree with the prior administration, and they want out of this lawsuit. They want to preserve the Affordable Care Act. The ability to withdraw from this lawsuit has been made more difficult, however. The Wisconsin legislature, before the new governor and attorney general could take office, in an extraordinary session, passed some legislation that said you need legislative approval to withdraw from this lawsuit, and they signaled that, of course, they were not going to allow or give that approval. That went up on legal challenge, and the first judge that heard this case issued an injunction to the legislature and said, no, governor and attorney general, your powers cannot be limited in that way. You have the ability to go ahead and withdraw from lawsuits like this if you want to. So the Wisconsin attorney general very quickly filed motions to withdraw from two different challenges to the Affordable Care Act. One of them being Franciscan Alliance versus Price, the other being Texas versus United States. And we have a separate video case tip on that Franciscan Alliance case. This one is on Texas versus United States. Well, after that first judge ruled, Wisconsin asked to pull out of that lawsuit, but then that case went up on appeal in Wisconsin of whether or not the attorney general could have withdrawn from that lawsuit. And that litigation in the state of Wisconsin is ongoing. So Wisconsin was waiting to hear what those Texas judges would allow with this request to pull out of Texas versus United States. And we got our answers. First, Wisconsin was allowed to leave the Texas versus United States suit at the district court level. That order was made by Judge O'Connor on April 2nd. Wisconsin then had to just sit tight and see if it would be released from the appellate court case, because Texas versus United States was up on appeal to the Fifth Circuit Court of Appeals. And Wisconsin was sitting tight waiting for that decision. And as of April 5th, it has been released from that appeal as well. As you can imagine, the administration in Wisconsin was quite pleased to hear that. In fact, the tweet came from Attorney General Josh Kaul quite quickly that said the state of Wisconsin will no longer be using tax dollars to support this lawsuit, which is contrary to the interest of all Wisconsinites. They are quite pleased with the ability to no longer have to be in a lawsuit arguing against the Affordable Care Act. You can read some of that paperwork that goes along with this court decision, the dismissal order from that district court, and a lot of the paperwork that Attorney General Josh Kaul filed requesting permission to leave. Wisconsin is now officially out of both challenges to the Affordable Care Act. Those lawsuits, however, do continue. Wisconsin's just not a party to it, but they still are ongoing in the courts, and we'll keep you posted as they make their way through their appeals. If you have questions on this case or other issues about health care and coverage in the Affordable Care Act, you can send us an email, and you can find us at healthwatchwisconsin.org.